reviewing our top 5 applicants for the Voting Rights Act attorney position. We are now on Munger, Tolles, and Olson. Okay. Does everybody have their files in front of them?
Yeah, they weren't on my short list, and the main reason, and this might just be being the non-lawyer again, but I saw a lot of background on election law and public finance. I just didn't see anything on Voting Rights Act experience, so for that reason, they were not in my short list.
Yeah, that was my concern. I had them, I think I just added them as a 5th, but I didn't really, they didn't make my top 4. I think they have extensive election law experience more generally. Some of the cases that they cite to had Voting Rights Act claims. It's not entirely clear that they worked on the Voting Rights Act claims themselves. So for that reason, I thought they just ranked lower. There's, I think, a lot of litigation experience. They bring, again, the advantage of this is one of the largest firms in Los Angeles. Again, a lot of very strong general election law experience, particularly around campaign financing and other sort of related issues, constitutional issues. But I simply didn't rank them that high because of their, what I saw was an absence of directly relevant experience under the Voting Rights Act.
That's my biggest concern about them. I think that's one of my biggest concerns about them was their lack of Voting Rights Act experience. And if we interview them, I think that is the question they have to address. I mean, the rest of the stuff, they've got plenty of capacity, but I'm just not sure that they've got, that they've got the VRA experience that we need.
Okay. Well, for those who did vote in their favor, would someone care to speak to at least on the voting rights? And we are going through the criteria here, so does anyone want to speak to the voting rights?
They're on my list because of their extensive election experience. Okay. I mean, with really heavy hitters in the election area.
Okay.
But I did so recognizing that there was less voting rights stuff.
Commissioner Ward?
I can only speak for myself. I know that Commissioner Filkins-Weber had them highly rated on her list. For myself, yeah, I believe they were ranked number 3, as I recall, on her list. I don't know why. I mean, I don't know her rationale behind that. For me, though, again, I thought their election law experience speaks well to their capabilities and experience. And I strikingly remember about them that they, being counsel for the plaintiffs in Common Cause, having worked with Common Cause and kind of their broad field of clientele, they certainly seem to be able to, again, play all sides of the field and expertly so. So I just thought their experience and their impact was striking.
Commissioner Blanco, do you have any comments?
Yeah, and again, I'm going to disclose that I know Mr. Phillips, and I haven't worked with him directly, but I've co-counseled with this firm many times when they were doing pro bono work for both Maldiv and the Lawyers Committee. So, I don't think it disqualifies me. I think it does actually give me a little insight I can share with you. I had not included them in my top because of the lack of Voting Rights Act, direct Voting Rights Act experience. And I knew that we had other people in the pool who did. If we had not had other highly qualified people in the pool with voting rights experience, I would have included them for the following reason. Besides the sort of election law work that they've done a lot of constitutional law, and I know that from this application and also just knowing the firm's pro bono work. And a lot of the cases that we're going to be dealing with, the Bartlett case, a lot of the cases that everybody cites here, are actually equal protection cases where a district is challenged under equal protection constitutional grounds that it favors one, that it's a race that it's a unconstitutionally racially based district under the equal protection clause. And so a lot of the analysis actually under Voting Rights Act is constitutional. I mean, in voting litigation is actually constitutional litigation. And I do know, and he discusses the fact that he has constitutional law experience. So, that if we were looking at if we didn't have depth of voting rights, I would say that they're high up because of their constitutional law experience, which does matter here. Where it gets complicated is that in anticipating sort of Section 2 type challenges, where somebody says you should have maximized voters, all that really is Section 2, whereas when you sue because of a quote-unquote racial gerrymandering, then you're looking at a constitutional claim. So that's a lot of legalese, but I'm sorry. But it is, I mean, they do have that constitutional expertise. Brad Phillips is highly, highly regarded as an attorney in California. I mean, by everybody. And the firm is a very highly regarded firm, and they do excellent work. And when they do something pro bono, I can say that they treat you as if you were a paying client. All the resources, all the time. I've worked with attorneys there that have gone to the California Supreme Court on civil rights cases. So I think it's a very good firm, and with a good public-minded, group of lawyers and management team, if you want to put it that way. Their management team, I think, has encouraged that culture in the firm. And I don't see any conflicts, which is really helpful. But there is this issue, Now, I would point out that I would ask if we put him in the pool and we keep him in the pool, that it does say that there was equal protection and voting rights challenge that they did to the use of pre-scored punch cards. And I don't know what that challenge was under what kind of voting rights challenge that was, under what section of the Voting Rights Act. I can see that the first one is an equal protection, but I can't tell what the voting rights is. On cost, they give their normal billable hours, which, just always amaze me. But there, it makes me wonder why I went into nonprofit law. But it is a substantial reduction, the $2.50 an hour. And again, we would have to really do our own math and figure out how many hours we would need. But that is, anybody who knows this knows that's an incredible reduction in rate for these attorneys that bill very, very high, especially Brad. Mr. Phillips. Looks like they've advised clients. I don't know that they did work with on the LA School Board electoral district lines, which is interesting. He was, I guess the professor was on the commission and they worked with him, so that's some commission work. And some electoral district line work, if you look at page 4. So I feel they're reasonable on the cost. I don't see conflicts. I think they have a large firm capacity as we discussed, and I know in my experience with them, they've really made it available, even if they're working at a discounted rate. And I think what we should really explore is what was that one redistricting experience, and also how do they think their constitutional law, how would they get up to speed on Section 2? How quickly? And what is their constitutional, how do they feel constitutional law experience is applicable to our work? And lots of litigation experience I saw in there.
With your knowledge of the firm, we have this thing, the trust factor.
Yeah.
What's your sense on the trust factor as far as you have any background?
My sense that there would be very high trust. The firm is mainly LA and San Francisco, and I'm more familiar with San Francisco pro bono work, but I do know that they do that also in LA. And I think there's a sense that they have always stepped up to sort of the public's need, like you can see with all the election stuff and campaign finance, and I know that I work with them on civil rights issues. I think there's a sense that they're a firm that hasn't really been a firm that's worked for parties. They may be a corporate firm, and they have corporate clients, of course, and they're a for-profit and all of that, and on and on. But that where they have gotten involved in the political process, it hasn't been for partisan groups, but rather for the public. That's my sense.
Commissioner Ward, I just wanted to clarify Commissioner Filkins-Weber's rankings, because I had 5 from her, and it did not include Munger, Tolson, Olson. I just wanted to clarify. I know you've read them twice already, but I had GRD Consulting, Hebert, Nielsen, Merksimer, White and Case, and Gibson Dunn were the ones I had for her.
I didn't follow your list, but I was right. It was her third choice, and it was marked as such on the tally sheet. If you'd like me to reiterate those, they were Nielsen, Merksimer, and Leone, Gibson, Dunn, Munger, Tolles, White and Case, and Gilda Daniels.
And those are the 5, and from my notes, those are the 5 I have.
Right.
Great. Thank you.
I was curious on the conflicts of interest clause, is if their last point is just kind of a standard statement, or if that's something that the panel would want to further define. To read it, it says, other attorneys and employees of our firm or members of their immediate families may have conflicts of interest as described in Government Code 8252, or subsection 4 of Section 6 of the RFI.
What is it? I'm sorry?
Page 5, item number 4, conflicts of interest, last paragraph.
Okay.
Well, I think that's sort of a catch-all, which I think is good to have there. That there may be some other conflicts, but as with any large entity, might be somebody in there who could present a potential conflict. I'm assuming they haven't done an investigation of the whole firm to see whether there's a conflict, and they put that in there for that reason. But and on the other hand, they probably would firewall anybody else who isn't listed here. So there wouldn't be a conflict. But
was my assumption. I just didn't know if that's something we need to put on the question list or not.
It is. We should ask them. I think it's partly standard and perhaps not. They're a very well-known firm in LA for just getting involved in the public life. So I think they may have people that in the firm that have gone in and out of government.
Yeah, and there may be litigation against the state of California.
I mean,
that is not listed here.
Yeah. So I think it's a catch-all, but they are a pretty high-profile firm that gets involved in a lot of issues. So I wouldn't be surprised if they have firm members that have been judges and elected and all those kind of things.
Yeah, I think if we're going to advance them, I think that's certainly something we'd want to ask, and particularly because, again, and they do mention, at least with regard to Mr. Phillips, some specific areas where he had represented clients and does represent clients that are basically adverse to either the state itself or a state agency. other thoughts? To be honest with you, I just didn't rank them as high.
Yeah.
And if we're drawing a cut, I have no problem taking them off the list.
I would tend to
That's my
agree. I
feeling.
mean, I think it sounds like they're a solid, law firm, but they lack the direct experience that we need, and I don't want to be the part of the building experience on the resume client at this point in time.
Yeah, that's my biggest concern. I have no doubt they can get up to speed, but I don't want someone to have to get up to speed. I want someone who's already at speed to advise us as quickly as we need them.
Yeah, I'd be willing, I mean, I respect them highly, and I've done a lot of work with them, but I actually had them as a no. And then when we said we had to go to 5 candidates, I put them in, but they were not in my top 3 because of the lack of Voting Rights Act experience. So they were not in my top 3.
Me neither.
Is there any strong sentiment regarding keeping them at this point? In terms of having so that's
No, I think that of the 5, although the firm pedigree is terrific,
absolutely, yes.
that the absence of direct voting rights, I kept looking for it. I mean,
Yeah.
and the pedigree is what made the cut initially. But
Yeah.
I would think the absence of Voting Rights Act is a. In all honesty, I don't know that I could vote in the last analysis for someone who had no voting rights experience to be our voting rights attorney.
Right.
Right, I think we need to be conscious that, if this is really going to be a waste of their time too,
Yeah,
that,
yeah.
why drag them through it? So,
I think, I can't speak for Commissioner Folkins, however, but I feel comfortable in saying that, being that her first 2 choices are represented in the pool still, she would be amicable.
Okay. All righty. Any further comments by the commissioners? Okay. Again, we'll.
Are we going to?
No, I'm gonna
Oh,
get
yeah.
to public
Okay.
comment
And
on this
summarize.
first.
Yeah, and then, yeah.
Yeah.
Okay.
So if there weren't any additional comments from, okay, so if there are members of the public that would care to comment on this applicant, please come forward. No? Okay, we have no public comment. In terms of decision-making, committee decision-making, do we pass motions or simply how are we acting as a body?
you're making recommendations.
Recommendation,
Yeah,
okay.
so this would just be part of your recommendation.
Okay. So no motioning required?
No, I think we would,
Well,
I would phrase it.
Actually, wasn't it delegated to this committee that you would choose who to interview?
I mean, we can have a final motion at the end of the day saying these are the 4
Right.
or 3,
Yeah,
whatever.
just for
don't need to-
neatness,
yeah.
in that this first stage is all within the committee. You're making your own determination as to who you wish to invite to come on Thursday. Then certainly following that meeting, you want a motion with a final recommendation to the full
So why don't we
commission.
just save that for the end, and we'll simply have a motion to recommend the applicants to move forward. Okay? Okay. Shall we just?
One more.
12:20? Let's keep going.
Go for it.
So we have Nielsen Merksemer, and no aspersions, of course, on the remaining partners. I'm just cutting it short there for the first 2.
So for me, I know that we had a bit of a discussion on this firm already. I personally have no argument with the experience of the folks involved at the firm here. However, I do think this particular firm, for me, presented kind of the most troubling conflicts questions. So I would invite my fellow commissioners who are actually on the committee to discuss that further.
Commissioner Ward?
Oh, thank you. Is Commissioner Blanco, were you going to take us through the matrix for consistency's sake?
Okay,
Thank you.
I would support that.
all right. I'll just say that they only got my vote again because we pushed for 5, and I had only 3 people I was willing to push forward even to the interview, and they were not among them. So that's why I think at some point would have been interesting to see how many are in there, because it's just they're in there as opposed to where they were ranked, because, anyway. So, I think there's no question on the first two parts of the chart, of the grid, that in terms of extensive redistricting experience, congressional, state, large jurisdiction, small jurisdiction, school boards, water districts, et cetera, and Section 2 and Section 5 experience, that this firm meets that, that part of our, what are we calling it? The RFI, or of our request. On working with public boards and commissions, the same, I think, especially maybe more than any of the other firms. This is one that works at a very local level with cities and counties and water boards again, and actually advises them before they do things about what to do or when they're planning to do something. And it looks like they engage constantly with public entities. So I think they rank highly there. I am a little concerned on the capacity, because somebody will have to help me with this, but I got I thought that they might be doing work again on redistricting. Did other people see that? That they're going to be...
Well, I know under Exhibit 2, and that doesn't give us...
Oh, there it is, yes.
It doesn't tell the depth of the experience,
Yeah,
but this
no,
is a lot.
yeah,
These are a lot of clients.
Right, so that's
dealing with.
yeah, that's exactly it. That's what I was looking for. I commented on this earlier. So in terms of capacity, I don't mean that to mean a skill or capability, but if we have a proposal for basically 2 team members, if I'm correct, no, 3. I guess we have 3 team members. That's a lot of existing clients, particularly around redistricting. These aren't clients for other matters, but going forward with the redistricting. I do have a question about overextension and what quality or how much time would we get from them, given their extensive other commitments. So I am concerned about other commitments. And the cost proposal, just to go back to it, I thought it was high. It was, let me get to that section.
It's up to 5,000 to 7,500.
Where is it? What page? Oh, here we go, at the last page. So it was 30,000 per month, which on its face, I sort of thought, well, 5 months, that's 150, that's within the range. But I was concerned with 2 things: that the attendance and travel, and location for the meetings, they priced at between 5,000 and 7,500. Whereas we had other people pricing it at 2,000.
Although I think their assumptions were different, because I think some of those early ones had 3-hour meeting assumptions versus 8 hours.
But there were some that
but
were
you're
for
right.
full
But you're right.
that were
You're
still
right.
at 2,000.
But just to note that they, at least there's they say explicitly they're talking about 8
Yeah,
hours. So
but I do think we
that's
have other
fair to
ones
know.
that are lower. But we could. That's a question to ask of all the candidates. How did you do your travel estimate? And then I was concerned with this last item that said this fixed fee. So it's fixed. It looks like this is fixed. Everything here, that would be, we'd have to ask how much of it is negotiable, because they do say it's fixed. But it says it would not include racially polarized voting analysis or legal analysis of the same. And I wasn't sure why they would pull out well, I do know why, because it's very time-consuming, and the legal analysis of polarized voting. And that would be billed at the normal hourly rates in addition to expert fees. I think expert fees is something we have to, we'll do our own expert fees. So I'm not worried about the expert fees. But now we're back at hourly rate and without, an addition for the legal analysis. I think that could run really high, so I think the 150 might be more like, I'm just guessing here, but it might be more like 250. And I'm concerned why that's not included in the original.
Yeah, I was puzzled, quite puzzled by that, because actually, I think that's one of the major responsibilities of the
Yeah.
Voting Rights Act Council, which is they're not going to do any kind of statistical analysis or review of the literature, but they need to advise the commission on whether the statistical analyses are sufficient to, say, create a possible Section 2 violation, or they're not. And I saw that as core to the to the job. So
Yeah.
I was very curious about why that was broken out that way. And I think the cost, if they're going to do it this way, I think the cost could be pretty significant.
Pretty high.
I think another thing, I mean, the billing I was somewhat troubled by was that they contemplate, the $30,000 is contemplated based on 60 hours a month work. That's a $500 an hour fee. That's on the previous page.
Oh, so that's
And 60 hours a week will hardly cover our meetings. I mean, our outreach meetings, let alone anything else. Also, you'll notice
right.
2 paragraphs above that, it says the legal services specified do not contemplate advice or assistance concerning a pre-clearance submission, which I'm assuming we're going to have.
Yeah, and that's something, I think that's something we'll have to discuss too, because I know, and Mr. Milk might be able to correct me on this, but I think it's been the State Attorney General's office has been handling, or maybe the Secretary of State's office has been handling other pre-clearance applications, but. And I think we need to figure out who's actually going to do that. But I think you're right. I think
An awful lot of big pieces got cut out
Yeah.
of what the
Right.
bill is.
You're right.
I mean, essentially, this is to have a lawyer sit there while you have your outreach meetings.
Right.
That's what this is about. I mean, you
They
know.
had the most terms in the
Yeah,
Scott
exactly.
section.
Yeah. No.
It's not this, it's not this, it's not this, it's not this.
Yeah. So my biggest concerns were around the conflicts and the fee questions. I think in terms of relevant VRA experience, they've got obviously that they're doing defense side and they've been advising a number of jurisdictions.
I wasn't finished
Oh, I'm sorry.
with my chart.
Oh, I'm sorry. I thought you got all the way down to cost.
No, I did conflicts.
Oh, I'm sorry. You don't have conflict. Forgive me. Well, anyway, I don't need. That's as far as I need to say anyway. But I think that they've, like everybody else, they've got tons of experience on the defense side.
So I do want to talk about the conflicts issue. I think I mentioned it before before I put him back in the pool, which is I am again concerned. I know that somebody mentioned the fact that Miss Leone could be perhaps firewalled, but I am concerned that the firm itself is a lobbying firm. And a lobbying firm in California, and that means you lobby the legislature, which means they have extensive relationships with elected officials, and who pay them to lobby. And so there's a financial relationship between members. You know, I mean, they're not paid to the electeds don't pay, but they're paid to lobby electeds, and so they have a lot of relationships. And I know that one of the things we were asked extensively about was, I mean, even in the interviews, when we would say we even knew somebody, we would say, how well do you know that legislator? How often have you worked with them? What did you do with them? And when the entire firm is a lobbying firm, I worry about being too enmeshed with elected officials here in Sacramento. So that's a concern for me. And then Ms. Leone's personal status as a registered lobbyist is of concern, and she lobbies on school board issues. She talks about it, I think, trying to find where she describes that she actually, one of her,
It's on page 12.
is it
Number 4.
page 12? Okay. Oh, right. So she's been registered doing school district boundary matters before the School Board of Education and very occasionally with the legislature. I was last registered to lobby in 2008. That's just a big, I think it's, there was the question about like if somebody no longer, but how long ago were they registered? I'd want to really probe why she stopped why she didn't re-up as her registration as a lobbyist. And the other thing, of course, that I think we all have commented about is that they've represented the Republican Party in California, even though the last time, and then the National Republican Party in 2003. Then finally, I would, in terms of the trust versus the conflict standard that some of the public has referred to, the work in Texas is very troubling to a lot of people across the country. The fact that the legislature, when the legislature changed political hands, even though the redistricting is supposed to occur every 10 years, that once it changed, there was the new legislature decided to do a mid-decade redistricting effort. And it was viewed this was in the news a lot, and it was viewed as a very partisan. The law allowed it, and it went to the Supreme Court, and the Supreme Court said you can do this, and you can do it as a partisan. They actually called it a partisan gerrymander that was allowable under the U.S. Constitution. For me, that's very troubling from a trust conflicts perspective. So that's what I have to say about the conflicts portion of the grid.
Additional comments on any of the criteria?
Just as a follow-on, Commissioner Forbes has suggested that, perhaps one solution that we might, assuming there's equal concern about the conflicts and the trust issue, to try to firewall Ms. Leone. The difference here is that although there's a team of 3 listed, it seems like Mr. Parinello, is that his name? Would only get involved if there's litigation, is the sense that I got. So it's mostly her and an associate, and that seems to be the way they've been teamed on other Voting Rights Act and redistricting cases. So I think the comment that we got from the public earlier, this would be a more complicated situation if we took her out.
Commissioner Chetta, they were in your pool in the early.
I was willing to interview them.
Yeah.
I have a lot of concerns about the conflicts too.
Do you have concerns? I'm just.
Yeah, well, to me, the real question was whether the conflicts were sufficient to disqualify outright versus probing them some more. And at least initially, I didn't feel I knew enough. There's a lot here, no doubt. But I wanted to ask a few more questions regarding these conflicts, because they may, in fact, be disqualifying. And I have some serious questions about their lobbying activity and their affiliation with one of the major parties. So I do, however, given how highly they will rank in other criteria, that is, again, directly relevant experience on the Voting Rights Act. Again, it's from the defense side. I don't think they have any compunction, and we shouldn't necessarily either in terms of just sort of screening. I feel that a defense side firm shouldn't be automatically disqualified. No. But given that, I didn't feel at this point I wanted to knock them out entirely, was my sense. But I have very strong reservations, given what I see on paper, and I'd want to explore them further, basically the ones you've identified. And I just sort of quickly looked at some of their some of the clients I have for lobbying, I didn't see anything necessarily disqualifying based on their clients, but
Counties, maybe.
there may be. And again, there are a couple counties that are being represented, and there could be, depending how we analyze it, some problems, right? And again, I just did a glance just 2 minutes ago. So I think we'd want to look at that more carefully and then explore those further if we go forward with them. But again, my sense is I felt in terms of past experience, they rank quite highly on that criterion. So I felt that we should go forward at least with an interview. But I would want to ask a lot of probing questions at an interview.
I mean, I rank them high on their experience, perhaps the highest. But both the trust issue, and I prefer the word trust and conflict as a phrase, and the billing thing is just,
Yeah, that's true.
Excuse
That's
me.
another thing too. That's
I mean,
really coming up.
those are real, red flags for me.
Yeah, I was really concerned initially, and I still am, about the conflict. The perception issues are really, really serious for me in terms of, the public. And we've already received some comments, I think, about this from the public. But in this last round, when we were talking about the billing, I had caught the issue that they were going to bill separately for the legal analysis around racially polarized voting, but I had not caught the issue of the preclearance legal work. I mean, I know the Secretary of State does that ultimately, but that's not what they're saying there. So I now have these it's like you said, what are we buying?
Right.
Especially that given that there's all these other clients they're representing, the cost capacity issues become a bit, almost as big for me as the conflict issues, which are the biggest ones for me.
Do you want to add it?
I think these are great questions for interview.
Well, is there any sense that, is there anybody who doesn't want to interview at this point? Just so we air those out.
I would not. Here's what I feel about the interview. I'll be fine, and we'll do the interview. But I feel like these conflicts and concerns that we've voiced here, this firm is not going to make it out of even
Right.
And I'm really concerned with, I believe in airing everything in the full body commission, but this has come up before. With this firm publicly, and commissioners have, voiced the same concerns, and I very much doubt that we'll get a supermajority for this firm, given what everybody has expressed publicly in the past already and today, which is what this decision takes, a supermajority. So I'm efficient about these things, and I just don't see why we would bring a person, do the interview, and then even go forward when I think there's a very slim likelihood that this firm would make it to the final selection, even to the final cut, or to be selected ultimately because of these conflict and perception issues.
And one of the conflicts that wasn't mentioned is the fact that they're currently representing counties that we are going to have to redistrict. And so I think that's actually a much more serious conflict than the fact that they've represented Republicans in the past or any of these other ones. So that's a concern of mine.
Commissioner Ward?
It sounds like we've beat it pretty good here. Yeah, I'd like to just kind of try to wrap it up with just, I guess, the comment that I do agree. I think your last conflict is actually the one I'm most concerned about. Again, not being a lawyer, I think that's something that I'd like to hear more about, especially in an interview. But first of all, I don't think it's fair to characterize that we're going to make a prejudgment on them, to say that they don't have a chance or things like that. I just really think that's unfair. This I don't think is an understatement to say a premier firm in this area. Their proposal here was, in my opinion, and again, I'm not a lawyer. I don't have connection to these things. I've had to self-study and catch up to speed. I don't have a horse in the race. But when I read their proposal, it was so thorough. I thought it was one of the most thorough as far as helping me understand a actual process to the redistricting, to our redistricting commission and our process. What particularly they're not just have done in the past, but what they're going to do with us. When I see their cost and fees, there's no. I'm concerned about that, but again, they have capabilities that they list that they're going to provide from the standpoint of having maptitudeability and being able to take whatever input our technical consultants offer in regards to Voting Rights Act districts and counties and things, and providing a legal analysis of that with options. I mean, that's again, as a layman, that's a big deal. I want that out of this expertise. That's something that the other ones don't offer. So are they on the high side? Yes, but they're also offering a premier product. Clearly, because of the amount of clients they have, again, this is not a shady firm. This is not people that are, have dirty hands. This is a very well-respected, very experienced, very accomplished firm. I just, like I said again, just as a member of the commission, a member of the public, I just think it's silly to discard them grossly based on some perceived conflicts of interest. Again, we all agree that when you have extensive experience and what we're looking for, absolute established expertise in these areas, there's going to be a little bit of baggage that comes with that. And again, it's our job to determine how much and if the commission can carry that. I completely agree. I'm not advocating for their hire at this point by any stretch. I'm not, wouldn't even begin to make that. But I certainly believe that not only are they, again, and would I be excited to interview them, I think that, again, we've highlighted, as they have, very effectively highlighted their conflicts of interest with no paragraph saying, and there might be others. She's very articulately spelled out anything that might be a problem. Obviously, it's important to her, and it's important to the firm. I get a sense that, again, they have these clients for a reason. I think they're a premier agency, and I not only would not rule them out simply because of some of these perceived conflicts of interest, I'm excited to interview them and see what they can do for us.
Okay. Commissioner Blanco?
Yeah, given that one of the things we do, why we structure both the commission and the advisory committees the way we do with all parties represented, I take very, very strongly, the position of the Republican commissioner here, and I would defer on that so that we really have every point of view represented, and we have this firm go forward for the interview.
I also would have them go forward. I mean, their experience to me is good enough to warrant letting them the opportunity to address I have very real concerns. I mean, I'm on the fiscal side here. I mean, what are we buying here? And the issues of the perception issues. But I would give them that opportunity.
Commissioner Dye, do you want to add?
I think it's fine if the committee wants to move forward to interview them. As a representative of the Finance Administration Committee, I did feel like they had the most, like I said, most terms under their cost structure, and a lot of what they seemed to exclude or had conditions around were things that I think we need. So something that, and you guys could choose to do this today. It's something to consider because you're not going to have that much time if you're going to do 4 or 5 interviews starting at 3 o'clock on Thursday, to talk about what do we think the hours are going to be, and therefore how reasonable are some of these, and what is the scope of work that we think we're going to need, and what would be reasonable to exclude, because as Commissioner Forbes said, we can all do the math. That's not the issue. That we need to get a handle on what we think a reasonable time commitment will be, and given that we think that this cut, they're all qualified people, you know, presumably the hours are not going to be wildly different. So that would be what I was hoping to get from today's meeting, was a sense of where we'd be out come budget-wise. And this one I felt was really squishy around that. So.
Well, I think it's a point well taken, and I think we're not. I don't want to sort of wrap up with just moving forward with the interviews. I think I would like to have some discussion around the questions and, as much as possible, flesh out for the full commission what our expectations will be in terms of hours, so that that is an informed interview as well. I'm inclined to move them forward. I have, like others, reservations, and I want to flesh those out. But I'd like to hear what they have to say. So for all the reasons stated, I think it's important to give them a chance. They're clearly very experienced firms, so I want to just talk to them. Okay. Any other commissioner comments before I invite public comments? Okay, so any public comments at this point on the firm of Nielsen Merksimer? I hope I'm pronouncing that. I hate firm names. I can never pronounce their names correctly. I'm getting somebody's name wrong.
Commissioners and staff, I wanted to make just a couple comments about this applicant. And I would agree with what seems to be the sentiment that this firm has a very high level of experience and knowledge about redistricting and the Voting Rights Act. In looking at the firm's work, I think one could think of two categories of work that they focus their redistricting efforts in. One is providing counsel to jurisdictions during the line drawing process. And then second is defending jurisdictions against claims either under the Voting Rights Act or the California Voting Rights Act. And I think the first category doesn't, to me, raise questions about public trust. And in fact, the commission is seeking its own counsel. The second category of work, I think, does potentially raise concerns about public trust. And I want to be careful not to disparage defense work per se. Every jurisdiction needs representation. Everyone has a right to counsel. But I do think that in terms of what's going to most effectively create and increase trust among California's diverse population, a firm that has done a significant amount of defense side work probably doesn't rank as high as compared to some of the other applicants you have before you. And then secondly, I would also suggest looking into the work that applicants have done on defense side and see the nature of the claims and the issues raised, the type of defenses employed by applicants. And I think that would be important to do with respect to this particular applicant. It sounds like the commissioners are proceeding with moving forward with an interview. And I think that given that, I guess I would just ask the committee to keep this question in mind of looking at the details of the defense side work this applicant has done, and also think about questions about public trust that this type of work raises. So I just wanted to give you those comments.
Thank you, Mr. Lee. Okay, well, we've is there any additional comments on this, or any sort of last comments on the group as a whole before we, at this point?
Are we agreed on 4?
Well, what I wanted to take a motion to advance. If it looks like 4, it'll be the 4, and then included in that motion have a direction to staff to contact them to join us on Thursday, and probably schedule some time on Friday just in case there may be some follow up. But Mr. Miller, do you want to comment, or do we need a motion?
Why don't we just, yes, let's do a motion because it's neat and clean. But my recollection is the thought was to ask a representative of the firm that is ultimately recommended to the commission to come to the Friday meeting and present to the commission.
The full commission?
Yes.
On Friday. Okay, so if we...
For all four?
For all four, we narrow...
No. The one,
it's a narrow
the one that you are recommending to the
Okay,
commission.
Yeah,
Right.
right.
Sorry if I misspoke.
Yeah, okay.
So I'll make a motion that
Okay.
we move,
And let's list the names of them.
yeah, I'm going to, that we interview the following applicants for the Voting Rights Attorney Council at our next meeting Thursday at 3 o'clock. Federal Compliance Consulting, GRD Consulting, Nielsen Merksimer, and Gibson Dunn.
Second.
Ms. Reese, could you read back the motion, please? Could you take that down? Could you, just following our custom of reading back?
The motion is to, the recommendation to interview for the VRA Council at the meeting on Thursday, Federal Compliance Consultants, GRD Consultants, Nielsen Merksimer, and Gibson Dunn.
Okay. Any discussion on the motion among the commissioners? Okay, would any members of the public care to comment on the motion that we advance these four applicants to Thursday for interviews? Okay, there are no public comments regarding the motion. Okay. Let's just do this by ayes. Okay, all those in favor of the motion, raise your hand and say aye.
Aye.
Aye. All opposed? Abstentions? Okay, motion carries unanimously. And I guess I would direct staff, if they can contact these applicants as soon as possible, get them lined up as well. What I'd suggest then is we take a lunch break, and then when we reconvene, we can discuss, again, various aspects of the interviewing process and some discussion about expectations for the position that we can recommend to the full commission. So it's about, I have 12:53 or so. How much time do we want here? An hour? Okay, so let's resume at 2.
I was just going to say, I think it would be prudent if we could call them right now.
Oh, yeah. Yeah, you can go. We're
We
going
could
to
just
have
get a
lunch.
little,
We're having lunch, Kurt. You have to call us. You can have lunch after you call.
a few more minutes on the other end to catch a sandwich.
Sure, yeah. No, why don't we, so it's almost 1 o'clock. What do you mean to resume at 2 o'clock?